We can go to position 18, Mr. Satterfield.
Good afternoon, Mr. Satterfield. You've been charged in case 25 CR 003225Y with simple assault family violence. Is there a history, Ms. Hardy?
The last arrest was April 16th, 2022, out of Atlanta for battery family violence, and that was null pros. They have 5 total arrest cycles, arrests out of Georgia and Tennessee. There's a 2020 misdemeanor conviction for theft by shoplifting, and it appears that they're on first offender probation for that. Nothing further.
Thank you. Ms. Fall?
Yes, Your Honor. If I may ask, pretrial, what was the case number of the case that you stated was, oh, I have it, the null prost case. Okay. Your Honor, this incident happened June 8th, 2025 at 7:07 p.m. at 2530 Nevis Road in South Fulton. Officer spoke with, I think it is Ray Reynolds, who stated he was sitting in the living room with Mr. Tony Gant when the defendant Mr. Reynolds' husband came in. Mr. Reynolds' husband, the defendant, began making threats toward Mr. Reynolds and Mr. Gant because he believed that Mr. Reynolds and Mr. Gant were flirting with one another. Mr. Reynolds then retreated into a different room, but the defendant's aggression escalated. At some point, Mr. Reynolds returned to the living room and the defendant retrieved a wine bottle from the kitchen and swung it at Mr. Reynolds in a striking motion. Mr. Reynolds was able to avoid getting struck by ducking and kind of dodging the wine bottle. The defendant claimed that Mr. Reynolds had a knife, but Mr. Gant, who was a witness, stated that Mr. Reynolds did not have a knife. Mr. Gant also confirmed the events and as stated by Mr. Reynolds, stating that the defendant also pushed Mr. Reynolds multiple times. Your Honor, as you heard, there was an open case 22 CR 002300J. That was a family violence battery and a criminal trespass that was later null prost. That case also involved the defendant and Mr. Reynolds being the victim and the defendant being the aggressor. And in that case, it was alleged that the defendant caused scratches to Mr. Reynolds by striking out at him. And also in the criminal trespass count, it is alleged that the defendant did damage a door by striking the door of their home. And so this is not the first time there has been violence in this home, or even the first time police have been called out and that Mr. Satterfield has been charged. We did have an opportunity to speak with Mr. Reynolds. He stated that he and the defendant are in a relationship. They live together at the incident location. He confirmed the events in the warrant. He stated this is not the first time the defendant has been violent toward him and not the first time police have been called, but it is the first time there has been an arrest, which appears to be contradicted by the fact that there was a previous case involving Mr. Satterfield committing violence against Mr. Reynolds. He also stated that he is currently filing for a TPO. He does not wish to have contact with the defendant, wants him to stay away from the residence, and the defendant will need a one-time escort to retrieve his belongings. Mr. Reynolds stated he would be on Zoom, so we would like to sound for him. Based on the fact that the defendant has that previous family violence, and there are 2 cycles in Tennessee, one in 2016 for assault, domestic bodily injury, and one in 2017 for assault, domestic bodily injury. Both had no dispositions. We are asking for a $2,000 surety bond, no further contact with Ray Reynolds. Stay away from 2530 Nevis Road, South Fulton. And we are requesting FEIP or 2-day anger awareness, no alcohol, drugs, or weapons. At this time, we would like to sound for Mr. Ray Reynolds. That's all for the state.
Thank you, Mr.
Your Honor, I'm not sure if it's my connection, but you seem to be breaking up a little bit.
I'm getting the same feedback. We cannot really hear you. You're chopping up very bad.
Okay, I'll do my best. If you can't hear
Much
me.
better now.
Okay, I moved it closer to me, so maybe that's it. Thank you. let's see, Mr. Reynolds, if you are on the line and wish to address the court, now is your opportunity to do so. This, I'm not sure if that is Mr. Reynolds is trying to get on there or not.
No, I see a name with Reynolds,
Yeah.
but that person does not appear to have turned on their video or audio.
Yes, Ms. McLeod, is this your case?
Yes, Your Honor.
Okay,
I would ask the court to consider a signature bond for my client because I believe the only thing that I've heard that he had a conviction of, and that was on the first offender, was not any kind of violent incident. This, I believe, was a shoplifting that I heard, Your Honor. My client is 31 years old. He tells me that he was definitely not the aggressor in this case. And also, I believe he's charged with simple assault. The allegation is that he had a wine bottle in his hand. Based on what I read in the warrant and what my client told me, it seemed like this couple was having an argument concerning infidelity. And my client did not hit anyone. In fact, he alleges that Mr. Reynolds had a knife in his hand. And even according to what they say in the warrant, the video that was taken, something is being said about a knife. So, of course, the facts are still in dispute. If the court decides to go with the state's recommendation that there be no further contact, of course, my client is going to need a one-time police escort to go back to the location to get his belongings. He tells me that he's currently unemployed and has been unemployed for at least a month, Your Honor, so he doesn't really have any money for a bond. Nothing further.
right, it will be a $2,000 signature bond through pretrial level 1 day anger awareness, no further contact with Mr. Reynolds, stay away from the Nevis Road address. He can go back to that address on one occasion with law enforcement to retrieve any belongings, no drugs, alcohol, weapons while out on bond. Good luck to you.
Next is position 4, Mr. Cameron.
Good afternoon, Mr. Cameron. You have been charged in case 25 CR 003241Y with 2 counts of simple battery, family violence, and obstructing or hindering persons making emergency telephone calls. Your history, Ms. Hardy?
The last arrest was April 20th, 2011, out of Fulton for obstruction. That is their only arrest cycle, nothing further.
Thank you, Mr. Soroka.
Thank you, Judge. This incident took place September 13th, 2023 at 2500 Center Street Northwest in Atlanta. It's the Etheridge Court Apartments. Law enforcement responded to a domestic call. Upon arrival, the officer made contact with the victim in this case, Ms. Kyra Epps, who explained that the defendant, her child's father, who shares a 1-year-old daughter with her, had attacked her in the apartment. A neighbor had asked the victim to call the defendant about a construction job, after which he hung up and texted her not to call him about the job. The defendant arrived to pick up their daughter, and the victim was asked to wait outside while she dressed the child. When she handed their daughter to him, he tried to push himself into her apartment or to get a stroller, even though she told him she was about to grab it for him. The defendant pushed her. And when she told him to leave the baby because he was being aggressive, she tried to call the police. The defendant then hit her with a closed fist in the back of her head and also broke her cell phone. After she was able to call the police using a different phone, the defendant brought their daughter back and then made threats that he would dog walk her if she came up the stairs and that she would die for playing with him about his baby. The defendant also threatened to send people to her house and that he would send shots at her door. The victim stated this was not the first time he had attacked her and that she had called the police on previous incidents. Their 1-year-old daughter did witness the assault, simple batteries here, when the defendant forced his way inside the apartment. The defendant was identified via driver's license photo and a warrant was issued for his arrest. I should note significantly here, there's an open case, 25 PI 003892, where the defendant is charged with aggravated assault, possession of a firearm or knife during commission or attempt to commit certain felonies, and aggravated stalking. This was for shooting at the same victim's new boyfriend, Christopher, damaging a wall at the same location as the one here, Judge, where another resident, another victim, Miss Angela Wallace, was, and the defendant was also charged with aggravated stalking for violating an existing TPO that our victim has, which I'll get to in a second. It's 24 CV 015185. We have spoken with the victim in this case. She confirmed they're no longer in a relationship and they don't live together, but they do share that one child. She confirmed the events in the warrant and explained that she had to file for a TPO against the defendant because he shot up her home in November of 2024. That TPO still currently active. It's that same one he violated. She explained this is not the first time he's been violent towards her, but it is the first time that police have been involved. She stated she doesn't want contact with him. She doesn't currently know where he lives. It's my understanding she's not going to be on the Zoom, but I would ask the court sound for her in accordance with Marcy's law. With the nature of this case, the subsequent harassment such that she had to take out a TPO, the fact that the defendant has apparently made good on his promise to engage in violence and to shoot up her residence. He's acted not just with his hands, but with a deadly weapon. There's a significant risk of reoffense to her, to others in the community that are just in the victim's life, or just live near her for that matter. And there's a risk of intimidating her as a witness here. We're concerned for her safety, her livelihood, and all things considered, the state is asking for a $10,000 surety bond, $4,000 surety on each simple battery family violence, $2,000 surety on the obstructing or hindering persons making emergency phone call, for him to complete FFIP, have no further contact with Kyra Epps, stay away from Etheridge Court Apartments at 2500 Center Street, Northwest, that apartment complex in Atlanta, surrender any and all firearms to the sheriff's office, have no drugs, weapons, or alcohol while out on bond. And that is it for the state. If we could just sound for the victim.
Couple of questions, Mr. Sirocco.
Yes, sir.
Concerning the November 24th allegations of the home being shot up, were there any criminal charges brought at that time aside from her applying for a TPO?
The TPO was in existence prior to that, Judge.
Okay,
So, but yes, the aggravated assault, the victim in that aggravated assault is Miss Angela Wallace, who happened to be living at that location. The bullets came flying and they struck the residence where she also was residing. And the shooting was originally intended for her new boyfriend, our victim's new boyfriend. So that's,
well, I guess I'm getting confused because you told me that was a 25 PI case number.
it is listed as a 25 PI case number.
Okay, but that happened in 24?
I would hold on. That's a good question. I'll see if I can clear that up.
Okay,
When I clicked on the case documentation, that is what showed up there.
all right, and so is this the 25 case do you know what the bond is on that, or was that why why he's here today on this 2023 case?
Let me look up the bond. I believe, if I could be thinking of another case, I don't want to speak out of turn. I believe it was a $30,000 surety. But I want to make sure before I inform the court.
Okay, I'll let you do that. Good afternoon, Ms.
Thank
Tucker.
you.
Is this your case?
Yes, Your Honor. So we're requesting a signature bond on each count. Mr. Cameron is a 32-year-old Atlanta native. He's maintained the same residence for basically his whole life. His mother owns the property. He works 2 jobs, one as a forklift operator. He's maintained that position for 2 years, and then one as a diesel technician. He's maintained that position for 1 year. He is a high school graduate. He does a lot of community service in his neighborhood. He has primary custody of his daughter who resides with him. And the mother, who's the alleged victim in this case, gets the daughter 1 week out of the month. He As mentioned by the state, the last arrest cycle for him was in 2011 when he was 17 years of age. He's 30 years old now. He has no prior failure to appears. So it's appropriate that we request a signature bond. In this case, the charges that were mentioned, while those charges are pending against him, they are not convictions. So I think that is important to note. He does not have those convictions on his record.
Judge, just to elaborate a little bit, that he wasn't arrested for the 11/24 until it was May 16th of this year. But that the offense date for that is 11/20/2024. What the other case that I'm talking about? It's 25 PI 003-892.
Okay, so he was
And he received-
arrested.
Yes, and a $30,000 surety on that.
Okay, so he was arrested for those cases. He had these outstanding warrants back from 2023, and so that's why he's here today in front of me. Okay, very good. Let's see, if Ms. Epps is on the line and wishes to address the court, now is your opportunity. Hold on, Mr. Cameron. I'll give you the opportunity to speak with Ms. Tucker if you need to. I'm trying to put it all together for you, sir. Thank you. So, Ms. Tucker, what you're telling me is that he does have employment and that he is the primary caretaker of the child that he has with Ms. Epps.
Yes, and they do have a no contact order. They've been using a third party, his mother, to coordinate exchanging the child for visitation, but he is the primary caregiver.
Okay. All right. With all that said, for each of the simple batteries, it will be a $2,000 signature bond through pretrial level 1. For the obstruction, a $1,000 signature bond through pretrial level 1 makes for a total of a $5,000 signature bond through pretrial level 1. No further contact with Ms. Epps. Stay away from the Center Street address. He is to abide by any pre-existing custody arrangements for the minor child. Third-party transfer for visitation. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Cameron. Who do we have next?
Your Honor. One second. Even though we gave him a bond through pretrial, he's gonna go to the SAP calendar because he has a no bond situation in Ohio.
Okay, thank you.
You're welcome.
I appreciate that, Ms. Bridgewater.
No problem.
So, Mr. Cameron, I'll see you back on my SAP calendar on June 24th regarding these charges.
Next is position 19, Ms. McLeod, I believe that's a waiver.
Okay, this is Ms. McLeod, are you with me? God, I'm happy to do this case now if you're with me. If not, we're gonna move on to someone else. Okay, who do we have next?
Good
Oh, here
afternoon.
she,
I'm here, Your Honor. I was having difficulty clicking this
okay.
on.
All right, Officer Milton, give me just a moment. Let me deal with position number 19, Aaron Spencer. It's my understanding there's a waiver, 25
Yes, Your
CR
Honor.
003226E, charged with simple battery. Is there a history, Ms. Hardy?
Yes, Your Honor. The last arrest was February 26, 2025, out of Fulton County for simple battery, reckless conduct, and aggravated assault against law enforcement. And that's open under 25 PI 001612. There's 19 total arrest cycles. There was a misdemeanor conviction in 2017 for criminal trespass. There's 2 open cases. The first one is 24 SC 001545, and that's aggravated battery, simple assault, terroristic threats and acts. And then 22 SC 180465, and that one is aggravated battery. There's FTAs from 2018 and 2019 and 3 probation violations, nothing further.
Thank you, Ms. Fall.
Yes, Your Honor. So I will try to make this as straightforward as possible. So it was on February 10th, 2025. Some inmates were engaged in a fight at the Fulton County Jail. The officers watched the video and took statements and basically determined that defendant Spencer exchanged words with a gentleman named Maurice Steele, who was in the jail, who was trying to diffuse a situation between 2 other inmates. Mr. Steele then walked away from the defendant. The defendant began exchanging words with Mr. Steele and then balled up his fist and struck Mr. Steele in the face. The 2 began fighting until officers broke up the fight. Mr. Steele did not have any visible injuries. As you've already heard, and I'm not sure if it was elaborated upon, the defendant has now been in jail for 756 days on multiple felony cases, 24 SC 001545, 25 PI 1001612, and a probation violation with an estate court case 22 CR 001271J. The probation violation was recent, the other ones are not. The defendant, this all happened in February. For some reason, a warrant was taken out in May, and then the warrant wasn't put on the system until 2 days ago. So we are fine to agree to a SOB through the jail, a $1,200 SOB through the jail. It was originally set at $1,200 surety bond. So we're agreeable to reduce that to a $1,200 signature bond through the jail. That will not resolve any of his issues that are keeping him in the jail at the moment. So we have no problem agreeing to a signature bond. That's all for the state.
Ms. McLeod.
No objection, Your Honor.
Very good. $12,000.
$1,200. No, it's
$1,200.
it's $1,200 signature bond. It was a $1,200 surety bond. We just want to convert it.
All right, $1,200 signature bond through the jail. No further, I guess, violent contact with Mr. Steele. No drugs, alcohol, weapons. All right, thank you, Ms. McLeod.
You're welcome, Your Honor. And if the court is amenable, Your Honor, I would like to readdress Mr. Porter's case. There's an issue, Your Honor, which I want to bring to the court's attention. I spoke to him after he appeared again.
What's the 15 and 16? What's the issue?
It was the one with his brother, Your Honor. What he
No,
tells
no. What is your issue? I gave him a signature bond, right?
Yes, Your Honor, but the issue is my client is disabled and he's about to be homeless. He's lived in this house by himself since 2007. The brother just showed up there 3 days ago. And that was the reason they got into an argument. So he's about to be homeless from a house he's lived in since 2007. And he has nowhere else to go and no means. So essentially, he's going to be on the street.
Is his brother staying at the house?
Well, he doesn't really live there. He only showed up 3 days ago, and that's when they got into the argument. His brother doesn't live there. Based on what he's
Well, I
telling
don't
you.
know. I don't know what the situation is. If his brother is living there, I'll give him that one-time escort. If the brother's not there, of course he can stay there. But if the brother's there, then he's going to have to find someplace else to reside if the brother is living in the home, and I guess file civilly to get him evicted. But if his
I
brother's
understand, Your Honor, but
if his brother's not there, then I'll allow him to stay there.
right, his contention is the brother does not reside there. He just showed up 3 days ago, and that was when they got into the argument.
No,
I
I
think
understand that that's what he's saying, but I can't go on just what he's saying. If he's to have no further contact with him and his brother is there and he's been allowed to stay there for some reason and they have some type of a state problem, that maybe his brother has a right to be there.
I understand.
I don't know. So if his brother, what I do know is that they can't be around one another. So if his
I
brother's there,
understand,
he's
Your
gonna have
Honor.
to, I empathize with his situation, but he's gonna have to find someplace else to go.
I think what he's saying is that the brother does not live there at all, and they had an argument when the brother showed up there. That's my
Okay,
understanding of what he's saying, that this is his home since 2007.
okay, I understand. And if his brother's not there, then he's allowed to reside there.
Thank you, Your Honor.
All right, very good.
That concludes
Yes,
my business before the court today. May I be excused?
yes, I appreciate it. Have a good rest of your day. Thank you.
Thank you. You too, Your Honor. Thank you.
Officer Milton, good afternoon.
Good afternoon, Your Honor.
Oh,
Miss Position number 1.
okay, let me address all the young ladies that are there at ACDC. Good afternoon. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We're providing you with the assistance of a public defender this afternoon if you choose to utilize their service. Ms. Burrito, you've been charged in case 25 CR 003236J with battery family violence and 2 counts of simple battery family violence. Is there a history, Ms. Hardy?
No, Your Honor, no history to report at this time.
Yes, Mr. Sirocco?
Thank you, Judge. This incident took place June 7th, 2025 at 1301 Spring Street Northwest in Atlanta. It's an apartment complex. Law enforcement responded to a fight in progress call and upon arrival made contact with the victim in this case, Mr. Tyler Finley, who explained the defendant, his live-in girlfriend, with whom he has a 3-month-old, got into a verbal argument that turned physical. He was punched in the face after trying to retrieve his belongings from the defendant and then grabbed the defendant by her arms and took her to the bathroom counter to try and calm her down. The defendant scratched the victim across his torso during that dispute, punched him multiple times. After he left the bathroom, he was punched in the back of his head. And when he left the apartment to get space from the defendant and re-entered, she spit in his face, which she admitted to. We've spoken with the victim in this case. He confirmed they are in a relationship, that they live together at the incident location and share a child. He stated that the defendant was trying to pack his belongings, and when he grabbed his bag to stop her from packing his belongings, the defendant tried to snatch it and then had hit him in the face. He believes that to be an accident, but when he was trying to calm her down in the bathroom, the defendant began scratching him on his chest, and the defendant then called the police to try. The defendant then, according to the victim, then called the police to try and de-escalate the situation. He does not want her to be in jail, stated like this hasn't happened before and he's not in fear of her, wants to continue contact. We would ask the court to sound for him when appropriate. We are not okay with no further violent contact at this point. This is a fresh incident. This was from June 7th, just 2 days ago, and it sounded pretty contentious here. We'll be asking for no further contact, though we are okay with a signature bond. We'll consent to that through pretrial services, 2-day anger awareness, no further contact with Tyler Finley, stay away from the apartment complex at 1301 Spring Street, Northwest Atlanta. and no drugs, weapons, or alcohol while out on bond. And yes, if we could just sound for the victim.
Mr. Tyler Finley is on the line and wishes to address the court. Now is your opportunity. Yes, good afternoon, Mr. Finley. If you could raise your right hand for me, please, sir. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can place your hand down. Thank you, sir. What would you like to tell the court?
Your Honor, I want to make it clear that I did not want to press charges against Ms. Rose Barreto. The situation happened during the argument about who needed to leave the apartment. That's why the police were called in the first place. It was not because things got physical or anything like that. Once the officer arrived to hear the story of what was going on and why someone needed to leave, he took it upon himself to call a supervisor and basically turn something that was supposed to be simple, which was to to get someone to leave the premises, into a domestic case. She had a bag that she was packing my clothes in. I grabbed the bag from her, and in the midst of that, her arms flailed and hit me in the face. Yes, she did scratch me while I was taking her to the bathroom. This has never happened before. She's a great person, a great mother, and I've always known her to be respectful, responsible, and supportive. I'm not afraid of her at all whatsoever, and I don't consider her a violent person. So I think this was a misunderstanding that got out of hand during a stressful moment. And I want to, move forward peacefully and focus on building our family.
Thank you, sir. Do we have something going on with the Zoom call?
I'm looking, Judge. I'm trying to figure out what happened.
Okay, so it's not just me. Okay, there we go. Thank you. All right. Thank you, Mr. Finley. I appreciate that. Ms. Tucker, is this your case?
Yes, Your Honor. Ms. Barreto is 23 years of age. She moved to the Atlanta area about 3 years ago. She does have parents that live in the area as well. She does not have any prior arrests, also no prior failure to appears. So we are requesting a signature bond on her behalf. We would ask that she be allowed to return to the residence at 1301 Spring Street Northwest. As we heard both from the state as well as the alleged victim, Mr. Finley, there have been no other instances of violence in the home. So we will also object to the state's request for no contact between Ms. Barreto and Mr. Finley, as they do have a 3-month-old child. I do understand that the incident is fresh, but it would be difficult for them to parent together, especially considering they reside at the same place. Her name is on the lease alongside his. So I am requesting a signature bond as well as her being allowed to continue to reside at the residence and no further violent contact between the two.
Just to reiterate, the police felt like they needed to be separated here. They themselves sought separation as underlying facts of the case. So we think a stay away, no further contact, again, is appropriate.
Now, given what I've heard from both Mr. Finley and the reasons that he tried to get the police involved, and that there have been no further instances before, and that they have a 3-month-old child, I'm not going to separate a family that has a 3-month-old child. They will have no further violent contact amongst each other, and I'm going to order 1-day anger awareness, but I'm not going to separate a family. For the battery, it's going to be a $2,000 signature bond through pretrial level 1. For both of the simple batteries, a $1,000 signature bond through pretrial level 1 makes for a total of a $4,000 signature bond through pretrial level 1. 1-day anger awareness, no further violent contact with Mr. Finley, no drugs, alcohol, weapons while out on bond. Good luck to you both.
Thank you, Your Honor.
Who do we have next?
Next is position 5, Mr. Coleman.
Good afternoon, Mr. Coleman. You have been charged in case 25 CR 003244Y with battery, willful obstruction of law enforcement officers, and one other misdemeanor offense. Is there a history, Ms. Hardy?
Yes, Your Honor, the last arrest was April 2nd, 2024, out of Fulton for simple assault. That case is open under 24 CR 001588Y. There are 16 total arrest cycles. There was a 2010 felony conviction for forgery, 2005 battery family violence, an FTA from 2017. Nothing further to report.
Thank you. Mr. Sirocco?
Thank you, Judge. This incident took place June 7th, 2025 at 719 Miami Circle, Northeast in Atlanta. Law enforcement responded to a call regarding a woman being sexually assaulted. Upon arrival, the officer met Miss Catherine Johnston, who explained that while she was walking in the parking lot, she could hear a woman being assaulted by a male who was forcing her to be silent. Miss Johnston stated that the sound was coming from behind the fence that divided 740 Sidney Marcus Boulevard and 719 Miami Circle. The officer and another officer drove to 719 Miami Circle, where they witnessed the defendant undressed and engaging in sexual activity, lying on his left side with a white female later identified as Miss Cheyenne Evans, the victim in this case. The defendant was detained and separated from Miss Evans. He refused to come out from the building, refused to comply with lawful orders to come out, and he ultimately used his body strength to make it difficult for them to detain him. The officer observed that Miss Evans actually had a bleeding nose and multiple bruises on her face. She stated that the defendant hit her in the face, causing her injuries. She had to be transported to Grady for those injuries, and the defendant was taken into custody. On a little bit more on his history, he does have, aside from what pretrial stated with that battery conviction, is an obstruction conviction that's from 01. He has several arrests for willful obstruction. 2009, null prost. 2016, that was null prost. That was a felony and 2 misdemeanor obstruction charges, in addition to a battery charge. Those were null prost, and a battery visible harm, willful obstruction, disorderly conduct, 2013, that was null prost. So it's not his first rodeo obstructing the police here. And as you've heard, he has that open simple assault case from 24 CR 001588Y, where he's been accused of picking up a shovel and rearing it to swing at another victim. But ultimately, this is a terrifying case. This is a man having sex with a woman in broad daylight, a woman who he beat severely and was trying to keep quiet from what Miss Johnston was stating. A woman who had to go to the hospital for her injuries. As of now, the state would need further investigation to pursue further charges relating to the defendant's carnal actions and evaluating the willingness of this victim to engage in that. But it sounds bad. And we'll be looking into it because we're very much concerned for her safety and the security of this person. Given the nature of the offenses and given the defendant's previous convictions for obstruction and battery, his previous cases for battery and willful obstruction, they go on, both felonious and not. His open assault case as well. He does pose a threat to this victim and to the community with this kind of activity. The state is asking for a $10,000 surety bond, $6,000 on the battery, $3,000 on the public indecency, and $1,000 on the willful obstruction, with the conditions of him completing SDET, 2-day anger awareness, having no further contact with Cheyenne Evans, no further contact with Catherine Johnston, and to stay away from 719 Miami Circle in Atlanta. No drugs, weapons, or alcohol while out on bond. We have not yet spoken to this victim. We will continue those efforts to reach her, but we would, of course, ask, in accordance with Marcy's law, that the court sound for her.
If Ms. Evans is on the line and wishes to address the court, now is your opportunity to do so. Does not appear so. Ms. Tucker?
Yes, Your Honor. Mr. Coleman is 54 years of age. He's had the same address for over 14 years, and although he is not an Atlanta native, he has been a resident since the 80s. He's obtained his GED, and he does maintain employment doing landscaping work on an as-needed basis, so basically part-time work. We are requesting a signature bond on his behalf, and if not a signature bond, the lowest possible surety bond. Although there have been a lot of charges against him, as the state read off, a lot of them were no pros, not a lot of convictions on his record. So we are requesting a signature bond on his behalf.
For the battery, it will be a $2,000 good bond. For each of the additional charges, $1,000 good bond each, makes for a total of a $4,000 good bond. No further contact with Ms. Johnston or Ms. Evans. Stay away from the Miami Circle address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Copeland.
Position number 9, Ms. Grill.
Good afternoon, Ms. Grell. You have been charged in case 25 CR 003234Y with driving under the influence of alcohol, driving under the influence of alcohol per se, and equipment violation headlights. Is there a history, Ms. Hardy?
No history to report at this time.
Mr. Nixon?
Yes, Your Honor. On June 7th, 2025, Sheriff's Deputy Cox was assigned to the traffic unit who was parked on the side of the roadway of Old National Highway inside the city of South Fulton. He observed a black Ford Fusion traveling westbound on Old National Highway without any headlights. The Sheriff's Deputy conducted a traffic stop on the defendant. Now, while speaking with her, the Sheriff's Deputy could smell an odor of alcohol. He also observed that her eyes were glossy, like being bloodshot. He asked her if she had any alcoholic beverages that evening, to which she stated she had one tequila sunrise 30 minutes prior to driving. Now, Sheriff's Deputy then asked her to do a standardized field sobriety test, to which she agreed. He explained and conducted the horizontal gaze, the Stagnus test, the HGN test, as well as the vertical test. The results of the test displayed 6 out of 6 possible clues. The defendant also gave a breath sample. Her breath sample registered at a 0.170. She was subsequently placed under arrest and then transported to the Georgia Tech Police Department, where the Sheriff's Deputy performed a breath test on the Intoxilizer 9000, to which she blew a 0.184, blowing double the legal limit. And that's why the state is requesting $250 surety for the equipment violation, $1,000 surety for the DUI per se, $1,000 surety for the DUI less safe, as well as ADET, and no alcohol, drugs, or weapons while out of bond.
Yes, Ms. Tucker?
Miss Grell is 25 years of age. She's been living in the Atlanta area since 2007. She's maintained the same residence for years. She's completed some college. She's been employed at Wolfson Eye Institute for over 10 months. And as read off by pretrial, she does not have a criminal history, and as well no prior failure to appears. So we are requesting a signature bond on her behalf today.
For the headlights violation will be a $500 signature bond through pretrial level 1. For each of the DUI offenses, a $1,500 signature bond through pretrial level 1. Makes for a total of a $3,500 signature bond through pretrial level 1. No drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Thank you, Your Honor.
Welcome. Next.
Next is position 23, Mr. Tucker.
Good afternoon, Mr. Tucker. You have been charged in case 25 CR 003230F with giving false information to law enforcement and willful obstruction of law enforcement. Is there a history, Ms. Hardy?
Yes, Your Honor. Their last arrest was August 22nd, 2023, out of Fulton for fleeing and attempting to elude and driving while license suspended or revoked. And that case is open under 24 SC 003380. There's 34 total arrest cycles. There's 2 misdemeanor convictions outside the last 10-year period. There's a 2016 obstruction and driving while license suspended or revoked. 2020 battery family violence. Nothing further to report.
Ms.
I
Falk?
also have a 2023 conviction for criminal trespass and disorderly conduct, a 2016 FTA, a 2016 NOLO for theft by shoplifting, and a 2016 conviction for a suspended license and obstruction of an officer. This incident happened May 7th of 2025. Officers were dispatched to 2498 Romaine Way in reference to a domestic disturbance. They spoke to Mr. Alfred Tucker, who stated he and his son were having a verbal argument about $20, and the defendant jumped onto his father's car as his father was attempting to drive away. The officers then spoke to the defendant, who identified himself as Michael Solomon with the date of birth of October 5th, 1980. Mr. Tucker corrected his son and gave the officers the defendant's correct name of Keith Tucker, which showed that the defendant had an active warrant for disorderly conduct. When the officers tried to place the defendant under arrest, he began running, and the officers had to chase him and then take him to the ground. As you've heard, this defendant has 35 cycles. His most recent conviction was 2 years ago for criminal trespass and disorderly conduct. He also has a current pending case under that 25 SC case that pretrial spoke of, the fleeing and eluding. For that reason, the state would recommend a $1,000 surety bond, $500 per count, no alcohol, drugs, or weapons, and that's all for the state.
Thank you.
Yes, Your Honor. He's 44 years old. Got a hold of his dad and fiance. They're on Zoom. He has a BA in English literature from a local university. He does auto glass repair as his own business, and he also does community volunteer work. We would ask the court to consider the lowest possible legal bond for him, including a signature bond if that is at all possible. Thank you.
Okay, for each charge will be a $500 good bond, makes for a total of $1,000 good bond, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Tucker.
Next is position 14, McNish.
Good afternoon, Ms. McNish. You have been charged in case 25 CR 003237F with battery family violence, simple battery family violence, cruelty to children in the 3rd degree, and willful obstruction of law enforcement officers. Is there a history, Ms. Hardy?
No, Your Honor, no history to report at this time.
Thank you. Mr. Nixon?
Yes, Your Honor. This occurred on June 6, 2025. Corporal Wyatt was dispatched to 2615 Dayview Lane in reference to a domestic. And upon arrival, the corporal made contact with the complainant identified as, I spelled the first name F-I-A-N, last name Manish, the victim who stated he was there to pick up his son to take him for the weekend and wanted a cell phone return. Now, Ms. McNish stated his wife, identified as the defendant, took a cell phone from their minor son, initials EM, due to him being on punishment. And when asked for her to return the phone due to him purchasing it, she refused. Now, while speaking to Mr. McNish in the driveway, the defendant exits the garage in her vehicle trying to leave while Mr. McNish was standing in the driveway with the corporal. The defendant got out of her vehicle several times, exchanging words with Mr. McNish. The corporal observed the defendant recording with her cell phone at a close distance to Mr. McNeish, causing him to react and grab her phone. Now, when Mr. McNeish grabbed the phone, the defendant threw several punches at the victim and bit him. The corporal had to separate both of the parties, and the minor child, initials EM, witnessed this and was hysterically crying. Mr. McNeish sustained a bite mark injury to his left forearm, and he was bleeding. Officers contacted the victim. The victim stated that they are married. They live together at the incident location. They share 4 children. The victim confirmed the events in the warrant and stated that this is not the first time the defendant has been violent towards him, but the first time the police has been called. The victim stated that he is currently filing for a TPO and stated that he does not want contact with the defendant and wants her to stay away from the residence. I believe the victim will be on Zoom. For these reasons, and based on the nature of the charges here, the history of being violent with the victim, and the victim currently applying for a TPO, the state is requesting $1,500 surety for the battery family violence, $500 surety for the obstruction, $500 surety for the cruelty to children in the 3rd degree, and $1,000 surety for the simple battery family violence. The state will recommend no further contacts with the victim. Stay away from 2615 Dayview Lane in Atlanta. No alcohol, drugs, or weapons while out on bond. Anger awareness and FVIP. And again, the state would ask the court to sound for the victim when appropriate.
If Mr. Fionn McNeish is on the line and wishes to address the court, now is your opportunity to do so. If so, I'll need for you to activate your camera and unmute yourself for me. Doesn't appear so. Mr. McLean?
Your Honor, 43-year-old Mrs. McNeish is a homemaker. She has a BA in community studies from university. The information I have about the home arrangement is quite different, that she lives there, child with the children, that he is a trucker who was going to take one of the children on a over-the-road trip for a few days, and that was the time at which this disagreement occurred. So there is the statement that she lives there and he does not, and they're going through a divorce, I believe, according to this information. And we would ask the court to give a signature bond, but she's asking that the court not forbid her from being in her own home. Thank you.
Okay, for the battery, it will be a $2,000 signature bond through pretrial level 1. For each of the other charges, a $1,000 signature bond through pretrial level 1 makes for a total of a $5,000 signature bond through pretrial level 1. 1-day anger awareness, 1 parenting class. As far as there's to be no further contact with Mr. McNeish. As far as the living arrangements, at this point in time, and they will have to work it out later, but at this point in time, given that she is the one that's before me, she is to stay away from that Dayview Lane address. She can go back on one occasion with law enforcement to retrieve any belongings. There is to be third-party transfer of any minor children for visitation. No drugs, alcohol, weapons while out on bond. If there is information, Mr. McLean, regarding that he will not be at that Dayview Lane address, and you would like for me to modify this bond in the future, I'm happy to do so.
Thank you.
Good luck to you, Ms. McNeish.
Next is position 8, Mr. Foster.
Good afternoon, Mr. Foster. You have been charged in case 25 CR 003246C with loitering and prowling and criminal trespass. Is there a history, Ms. Hardy?
Yes, Your Honor. The last arrest was July the 13th, 2022 out of Fulton for kidnapping, simple battery, criminal trespass. It appears that they're on probation. First offender probation, it looks like 22 SC 184888. There's a total of 10 arrest cycles, arrests out of Georgia and South Carolina. There's a 2020 felony conviction for domestic violence out of South Carolina. 2018 misdemeanor assault and battery. 2017 assault and battery. And these are out of South Carolina. 2016 aggravated assault, malicious injury to real property. Nothing further to report.
Thank you. Mr. Stratton?
Thank you, Judge. This incident took place June 7th, 2025 at 224 Woodward Avenue Southeast in Atlanta. Law enforcement responded to a prowler call at around 3 o'clock in the morning. Upon arrival, the victim, Mr. Connor Abdo, ABDO, came outside and explained that a male had attempted to enter his house by breaking his bedroom window. He explained the individual was still in his backyard. Officers went around both sides of the house and had hopped fences to access the backyard, where they located a male matching the description given by the victim, identifying him as the defendant here. The victim explained that he was sleeping when he heard his window break. Upon waking, he yelled at the male and then called the police. The law enforcement observed that the only way into the backyard here was by jumping the fence. The defendant admitted that he jumped the fence and broke the bedroom window, though he stated he was doing it because he was fleeing men who were trying to rob him. The officer then placed the defendant under arrest here, observing the broken bedroom window here and taking into consideration all the circumstances. There are a number of previous convictions, primarily in South Carolina, as you've heard, with respect to assault and battery in the second degree, in the third degree, again in the third degree, along with malicious injury to real property in 2016. The prior two I mentioned were 2017, 2018. More recently, domestic violence in the first degree, 2020, and First Offender Act, as you heard, to criminal damage to property in the second degree, and aggravated assault. So this is not his first time damaging property. Well, I'll say this. We've spoken with the victim here. He explained he doesn't know the defendant, explained that the defendant was trying to actually climb in through his window after busting it. The damage is going to cost, in his estimation, around $1,000 to repair, which would make this a felony. We'll be looking into getting an estimate from the victim regarding a felony upgrade. He explained to us that he wants no contact with the defendant and wants him to stay away from the residence. He should be on the Zoom. We would ask the court sound for him when appropriate. This is a scary case. You have someone who is hopping a fence at 3 a.m. to get into a residential backyard and busting a window. Imagine waking up to that. With that and the defendant's previous convictions from South Carolina for injury to property and the abrupt and scary nature of this case, the state is asking for a $3,000 surety, $1,500 for each count. No further contact with Connor Abdo. Stay away from 224 Woodward Avenue, Southwest Atlanta, and no drugs, weapons, or alcohol while out on bond. And if we could sound for Mr. Abdo.
Mr. Abdo wishes to address the court. Now is your opportunity to do so. If you raise your right hand for me, please, sir. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can place your hand down. What would you like to tell the court, sir?
So first off, I have security cameras around my house, and I reviewed the footage. There were no men chasing the defendant, so that part was not true. All of my gates were shut and locked, and I have footage, so he went around and he did have to jump over the gate to access the side of my house where my bedroom was. My girlfriend was also sleeping in my bed with me. She lives in my house and was extremely traumatized by this experience. We have footage of him like when he broke the window. We have the sound footage and how traumatic it was, the screaming, the yelling. I stood up and I stepped in the glass, and I have cuts all over the bottom of both of my feet from the damage. And I do have to get my window completely replaced. We are going to have to update our security systems and all of that. So based on the history and everything else, like we definitely would like the defendant to be kept far away from our property.
Okay, thank you for being here this afternoon, sir. Ms. Tucker, is this your case?
Yes, Your Honor.
You can proceed.
Mr. Foster is 30 years of age. He's lived in the Atlanta area for about 5 years. He does have family in the area as well. He's completed certification as a medical assistant, and he's recently been started employment at Delaney's. We are requesting a signature bond for both charges for him, if possible, if not the lowest amount in surety. He's not able to pay a $3,000 surety bond at this moment because at the time of his arrest, he did have his wallet on him. And the officers left his wallet on the ground, so he doesn't currently have any access to his finances to be able to pay his way out, and he hasn't been able to contact anyone to help him to get a bond. So due to his current financial situation, we are requesting a signature bond or the lowest possible surety that this court will grant.
For each charge will be $1,000 good bond, makes for a total of a $2,000 good bond. No further contact with Mr. Abdo. Stay away from the Woodward Avenue address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Foster. Who do we have next?
Right, Your Honor. Position 20, Ms. Thornhill. No, her. I'm sorry, 17, Price, 17, Ms. Price. Thank you.
Good afternoon, Ms. Price. You have been charged in case 25 CR 003247E with simple battery and simple battery in a public transit vehicle or station. Is there a history, Ms. Hardy?
Yes, Your Honor. The last arrest was September 22nd, 2024 out of Fulton for battery, family violence, and cruelty to children. That's open under 25 PI 000109. They have 2 total arrest cycles, nothing further.
Mr. Nixon?
Yes, Your Honor. On this incident, the officers were dispatched to a dispute call at 70 Hamilton E. Holmes Drive. Upon arrival, he spoke with Officer Worthy from MARTA. Officer Worthy stated that he had been notified of a dispute that took place on a Cobb County Transit bus near the I-20 East and I-285 bypass intersection. Officer Worthy stated that he was told that the defendant had attacked Mr. Deshaun Johnson, and Officer Worthy stated that the defendant admitted to attacking Mr. Johnson, at which he took her into custody. Now, after speaking with the officer spoke with Mr. Johnson. He stated that he was on the bus with his friend, Mr. Montavious Thomas, when the defendant turned to them and told them, "Stop staring at me. Don't like disrespectful little boys." Mr. Johnson stated that he and Mr. Thomas ignored the defendant. Mr. Johnson made a comment to Mr. Thomas, and at that time, to which the defendant turned to him again and asked him to repeat himself. He repeated himself, and at that point, the defendant punched him in the forehead. Mr. Thomas corroborated the events. We spoke with the victim. The victim stated that he does not know the defendant. The victim confirmed the events in the police report. The victim stated he wants no contact with the defendant and wants her to stay away from him. I believe the victim will try to be on Zoom. With regard to that 2024 battery, family violence, and cruelty to children in first degree, I know that I think it was a $40,000 straight bond. Conditions were related to the victim, and that was with Judge Carey. And as such, Your Honor, the state is recommending $1,000 surety for the simple battery, as well as $1,000 surety for the simple battery in a public transit vehicle, as well as no further contact with Deshaun Johnson, no alcohol, drugs, or weapons while out on bond, 3 days anger awareness. And again, the state would ask that the court sound for the victim when appropriate.
If Mr. Deshaun Johnson is on the line and wishes to address the court, now is your opportunity. Does not appear so. Mr. Nixon, do you know whether or not that transit bus is part of MARTA or not?
I think the bus is with Cobb County Transit, I believe, but the incident occurred on I-285, I-20 and I-285.
Okay, thank you. Mr. McLean?
Your Honor, her name is misspelled on the calendar, yet it is spelled correctly in the police report. It is Sonyika is her first name, last name Price. She's 31 years old, from Georgia all her life. Our contacts are here, community contacts are here. At a local large university downtown, she is getting she's got an Associate of Science in General Studies and is about halfway through to getting her bachelor's degree. She's a teacher, has worked in food service, and has been a caregiver. I read the police report as to what was said immediately before the allegation of physical contact. We would ask the court to grant her a signature bond, Your Honor.
Okay, for each charge will be a $500 good bond, makes for a total of $1,000 good bond. No further contact with Mr. Johnston, no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Price.
Next is position 10, Mr. Hamilton.
Good afternoon, Mr. Hamilton. You have been charged in case 25 CR 003231B with criminal trespass. Is there a history, Ms. Hardy?
The last arrest was May 13th, 2019, out of Douglas County for battery family violence. They have a total of 12 arrest cycles, arrests out of Georgia and Virginia. 2 felony convictions outside the last 10-year period. There's a misdemeanor conviction in 2016 for a DUI, 2009 obstruction, nothing further.
Mr. Nixon?
Yes, Your Honor, this occurred on June 7th, 2025. Officer responded to a call for service at Mazzy's Sports Bar and Grill located at 10729 Alpharetta Highway. That's unit 1424 in Roswell. And the reporting party stated that there was a male located within the business who had been trespassed prior to this incident. And upon arrival, the officer saw a black male outside the front doors of the property. The male was identified as the defendant. The defendant was actively arguing with the business employees at the front entrance. And as the officer approached, the defendant began advancing towards employees with his arms raised out to his side, seemingly enticing a physical altercation. The defendant was found to be intoxicated, and the defendant was subsequently detained. After being detained, the defendant was found to have been trespassed from the property on April 27th, 2025. And according to the reporting party, the defendant had arrived at the business, walked inside, and attempted to make trouble with the patrons. Regarding these facts and regarding the criminal history you've heard, Your Honor, the state's going to request a signature bond through pretrial services to stay away from the Mazzy Sports Bar and Grill located at 10729 Alpharetta Highway. That's unit number 1424 in Roswell. No alcohol, drugs, or weapons while out on bond, and alcohol drug evaluation treatment.
Tucker, is this your case?
Yes, Your Honor.
Okay.
Mr. Hamilton is 55 years of age. He's been in the Atlanta area for over 20 years. As mentioned by pretrial services, his last arrest was 6 years ago. He has no prior failure to appears, so we have no objections, and we also request a signature bond in this matter. We have no objections to stay away from the location, Mazzy's Sports Bar, as well as no objections to the rest of the state's recommendations in this matter.
Does he need the assistance of a social worker for housing or anything of that nature, Ms. Tucker?
No, Your Honor. He has a permanent residence at 602 Rosamond Parkway.
Okay. $1,000 signature bond through pretrial level 1. Stay away from Mandy's Sports Bar and Grill. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Hamilton.
Next is position 20, Ms. Thornhill.
Good afternoon, Ms. Thornhill. You have been charged in case 25 CR 003227C with unlawful conduct during a 911 call and false report of a crime. Is there a history, Ms. Hardy?
Last arrest was December the 19th, 2019, out of DeKalb for a probation violation. They have 8 adult arrest cycles, 2018 theft by shoplifting, 2019 battery, family violence, and disorderly conduct. Nothing further to report.
Ms. Falk?
On June 7th, 2025, the defendant called 911 and dispatched them to 2191 Sergeant Place Southeast in Atlanta around 4 p.m. She called regarding a family altercation between herself and her son. On the 911 call, she stated that her son, Cameron Thornhill, was armed with a knife and had threatened to harm her with it. When the police arrived, the defendant stated she intentionally made the false statement that her son threatened her with a knife to get the officer to respond to the call faster, which led to her being arrested for a false report of a crime and false and unlawful conduct during a 911 call. Even though she has 10 cycles, Your Honor, this is not a case that I foresee there being any issues regarding the Ayala factors. The state's recommendation is SOB through the jail, no alcohol, drugs, or weapons. That's all for the state.
Taking no objection to any of that, Mr. McLean.
The court is correct. No objection.
All right. For each charge will be $1,000 signature bond through the jail, makes for a total of a $2,000 signature bond through the jail. Only use 911 to appropriately report crimes and things of that nature. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Thornhill.
Thank you. Bye.
All right, see you next time. Thank you.
Next is position 12, Mr. Jackson.
Good afternoon, Mr. Jackson. You have been charged in case 25 CR 003235G with criminal trespass. Is there a history? Ms. Hardy?
No, Your Honor, no history to report at this time.
Thank you. Mr. Nixon?
Yes, Your Honor, this criminal trespass occurred on June 5th, 2025. Officers responded to the property of Polaris at East Point Apartments located at 3072 Washington Road. That's in East Point. After being given a criminal trespass warning by Ms. Maurice Hickman, the management team, the defendant returned to the property after being escorted off by officers, and the defendant was subsequently arrested. Seeing as though this is the defendant's first arrest, the state is going to recommend a signature bond through pretrial services. Stay away from 3072 Washington Road in East Point. Again, that's the Polaris at East Point Apartments. No alcohol, drugs, or weapons while out on bond.
Any objection to any of that, Mr. McLean? Or Ms. Tucker?
Oh, well, this is my case, Your Honor, and I have no objections to the state's recommendations, Your Honor.
Okay, given that this is his first arrest, I'm going to send him just through the jail. It'll be a $2,000 signature bond through the jail. Stay away from the incident location and no drugs, alcohol, weapons while out on bond. Mr. Jackson, I'm going to let you out, but you can't go back to that Washington Road address. Otherwise, they're going to put a warrant out for you again. So good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Next is position 11, Mr. Hutchinson.
Good afternoon, Mr. Hutchinson. You've been charged in case 25 CR 003232C with 2 counts of simple battery family violence. Is there a history, Ms. Hardy? You with me, Ms. Hardy? Okay, there you go.
audio's not working. Okay, there it is.
Okay,
There's no history to report for this defendant.
thank you. Yes, Mr. Nixon.
Yes, Your Honor, it's occurred on June 8th, 2025. Officers received a call for service at 3725 Princeton Lakes Parkway Southwest, apartment 3305. Upon arrival, officers spoke with the victim, Miss Yashika Marks. The caller stated that the male within the home, later identified as the defendant, slapped her in the face and kicked her in the back. Ms. Marks stated that she was having an emotional day and was in her room doing her hair after the defendant made her breakfast. Now, Ms. Marks stated that sometime after the defendant began to argue with her, Ms. Marks stated that the verbal altercation then escalated to the defendant slapping her in the face and knocking her phone out of her hand. Ms. Marks went on to say that the defendant also kicked her in the back, and Ms. Marks also stated that the defendant threatened to kill her. The victim did have an audio recording of the incident. In the audio, the defendant can be heard yelling at Ms. Marks, and he asks her, "Are you recording me?" followed by a loud smack sound, and then the audio ends. The defendant was determined to be the predominant aggressor and then taken into custody. Our office has spoken with the victim. The victim stated that the victim and the defendant are in a relationship. They live together at the incident location. They share no children. The victim confirmed the events in the warrant. And she stated that this is not the first time the defendant has been violent towards her, but the first time police have been involved. The victim stated that she is not in fear of the defendant and is okay with no violent contact. And the victim stated that she has left the residence and does not plan to return to live there at that particular residence. The victim still needs to get her belongings from the residence, and the victim will be on Zoom. Because of the facts listed here today, Your Honor, and the fact that this isn't the first time the defendant has been violent toward the victim, the state's recommendation is as follows. The state is going to recommend a $1,500 surety for the simple battery family violence, a $1,500 surety for the other simple battery family violence, for a total $3,000 surety. The state is recommending no further contact with Yashika Marks to promote a cooling off period, no alcohol, drugs, or weapons while out on bond, anger awareness, as well as FBIP. The state would also ask that the court sound for the victim when appropriate.
Ms. Marks, if you would like to address the court, now is your opportunity to do so. I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in if you choose to. Does not appear so. Ms. Tucker?
Yes, Mr. Hutchison is a 27-year-old Atlanta native. He's lived at the incident location, which is his residence, 3725 Princeton Lakes, for over 2 years now. His name is on the lease. He does maintain employment at Walmart. And as reported by pretrial, he has no criminal history, as well as, of course, no failure to appears. So it is appropriate that we request a signature bond for the counts in this matter. And we have no objections to no contact with Ms. Marks. And we just request that he be allowed to return back to the residence.
Okay. For each charge will be a $2,000 signature bond through pretrial level 1. Makes for a total of a $4,000 signature bond through pretrial level 1. 1 day anger awareness. No further contact with Ms. Marks. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Next is position 25, Mr. Williams.
Good afternoon, Mr. Williams. You've been charged in case 25 CR 003233J with simple battery family violence and simple assault family violence. Is there a history?
The last arrest was April 6, 2025, out of the city of Atlanta for a DUI. They have 8 total arrest cycles, misdemeanor conviction in 2005 for harassing phone calls. And they got first offender on that, and then there's a felony conviction for terroristic threats that falls under that same first offender. And the seal date is 2017. Nothing further.
Thank you. Ms. Fall?
Yes, Your Honor. This happened June 8th, 2025 at 3:35 a.m. at 6568 Earlhurst Road in Atlanta. Shakira Craig informed the police that she had been sleeping with the defendant, tried to wake her up and get her attention. Ms. Craig says the defendant often drinks on the weekends and attempts to get her attention by pulling on her arms. During the ensuing verbal altercation, the defendant picked up a Pinnacle French vodka bottle and brandished it at her in an intimidating manner and threatened to strike her with it. So it's just a glass vodka bottle. The defendant told police he felt disrespected in his home by his son and had a verbal argument which later turned physical, stemming from a conversation between him and his wife, Ms. Craig. Officers also spoke with Anaya Williams, who's the daughter of the defendant and Mrs. Craig, who stated that she overheard her parents arguing and saw the defendant forcibly pulling on her mother's arm in an effort to wake her up, demanding to speak with her. Ms. Williams encouraged her mother to come downstairs with her to get away from the defendant. And Ms. Williams also further corroborated Ms. Craig's statement regarding the defendant's intoxication on nearly every weekend. We did have an opportunity to speak with Ms. Craig. She stated that she and the defendant are married. They live together at the incident location and share 4 children. She confirmed the events in the warrant. She did state that the defendant has a drug and alcohol problem and she believes that he needs help. She stated the police have been called in the past for the defendant's disruptive behavior in the home due to his substance abuse, and that the police never made an arrest because they stated there was nothing they could do. The victim stated she is not in fear of the defendant and she just wants the defendant to get help and wants no further violent contact. The state does have one concern. When we were investigating the defendant's history, we saw a 2025 DUI arrest, which was not as concerning as the fact that the defendant had a simple battery, family violence, and cruelty to child 3rd-degree case that was dismissed in 2024. That involved the defendant and Ms. Craig, the same victim. In that case, the defendant had allegedly damaged several items in the residence, including the walls, television, dinner table, and door, and her vehicle windshield, and he allegedly hit her in the face with a closed fist. So contrary to what Ms. Craig had informed our victim advocate, it does appear that there had been an incident of violence where the defendant was arrested in 2024, and then the case was later dismissed. We also have a 2005 conviction for terroristic threats and acts and harassing phone calls. Based on the defendant's history and the previous incidents of violence involving the same victim, as well as this 2025 DUI arrest, and the fact that all of this was witnessed by their child, who had to tell the police what she observed firsthand, we are asking for a $3,000 surety bond, $2,000 for a simple battery, and $1,000 for the simple assault. No further violent contact with Shakira Craig. We're furthermore asking for ADET, random screens, 2-day anger awareness, and no alcohol, drugs, or weapons. Normally, we're vacillating between no further contact and no further violent contact. Based on the victim, Ms. Craig's statement, we believe potentially that we can attempt no further violent contact, but out of an abundance of caution, I would just like to say the state, if there are any additional arrests involving this defendant, Ms. Craig, we will move to revoke this bond. That's all for the state. We would like to sound from Ms. Craig at this time.
Ms. Craig, if you would like to address the court, now is your opportunity to do so. Yes, ma'am. If you'll raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, yes, ma'am. What would you like to tell the court?
I just wanted to state that he's not violent, how they're saying. I mean, those things that occurred before as him hitting me, I don't recall that from that past incident. I will say he is a good father. I think that just when he's under the influence, it caused him to talk and do things out of character that he probably wouldn't normally do. So that's why I say he needs some type of help with substance abuse. But far as like keeping him away from his kids and his home, I wouldn't say that. I would say give him a signature bond because he do have a job, a full-time job, and he do have a car note and other things that he do have to take care of and pay on a, monthly basis or whatever responsibility. Um, but yeah, I just really think he needs some type of counseling and help as far as like the substance abuse and other type of abuses.
Okay, what are the ages of the children that you have with Mr. Williams?
I have a 21-year-old, a 17-year-old, a 5-year-old, and an 8-year-old.
Okay, and the 17 and the other ones, are they still in the household with you?
Yeah, they all are here.
Okay. All right, I appreciate you being here this afternoon, ma'am.
You're welcome.
Mr. McLean?
Thank you, Your Honor. 40-year-old Mr. Cedric Williams is a Georgian all his life. He has a high school education and over at least 5 years. That's usually the amount of job history I ask for. Actually, for well over 6 years, he's worked in warehouse situations. We would ask the court to consider the lowest possible bond here, signature bond, if that is possible, and appropriate conditions. Thank you.
Okay. Mr. Williams, I don't want you to lose your job. I want you to be able to continue to take care of your family. But I do, from what I'm hearing, I am concerned. For each of the charges, it's going to be a $5,000 signature bond through pretrial level 2. That makes for a total of a $10,000 signature bond through pretrial level 2. I'm going to require that you undergo ADET, that's alcohol drug evaluation, and any treatment that's necessary. You're going to have random screens to make sure that you're not partaking in any drugs or alcohol while you're on probation. 1-day anger awareness. No further violent contact with Ms. Craig, and no drugs, alcohol, or weapons while out on bond. I'm making this a relatively high signature bond because if you violate this bond, then you're going to be right back where you are, and you're not going to have a signature bond the next time. It's going to be a $10,000 surety bond. So good luck to you, sir.
Next is position, Madeline Street, Mr. Whitehead.
Okay, so there was some issue with Mr. Whitehead's bond, is that right?
Yes, Your Honor. We were here in court on Saturday, and the Judge Law set the bond at a $1,000 surety bond. However, the defendant indicated that he had paid his bond through the East Point jail and had been brought to Fulton County before he could be released from East Point. I did reach out to Mr. McLean and send him an email, as well as PD Haddad, just letting them know if they could provide any paperwork that showed that he had bonded out from East Point, that the judge had indicated she would amend that bond to a $1,000 signature bond through the jail with no driving without adequate license, adequate insurance, and proper registration. So that's all we're waiting on.
So were you able to confirm that, Mr. McLean?
We have not yet confirmed that, Your Honor. This is an identical situation to something we had last week with the young lady.
I was here for that one.
Yep.
And you all were able to confirm that. Your client has his hand up, so I don't know if you need to discuss it with him, but I don't know what there is to dis. Give me a moment, sir. I'll have Mr. McLean speak with you. Have you attempted, let me ask, to figure this out?
No, Your Honor, I have not yet called the East Point jail, but intend to do so right away. The document should be able to be forthcoming. Last week with the young lady, their
Well,
problem
if you're not, we're not talking about that other young lady. If you're not doing anything to facilitate him getting this, then of course it's not going to get done. So I don't want this young man sitting there if he doesn't have to be.
Right. I think he's got some other matters, but we will call the East Point jail as soon as possible, but we just haven't had the time with the press of business to do that yet. And we'll do that.
Okay,
Hopefully,
right.
hopefully within a few minutes, we'll have an answer from East Point.
And
We
Your
have-
Honor, Your Honor, this is not at all intended to absolve anyone, but I will say he has a failure to appear on 24 SC 006153, where he's being held with no bond on a failure to appear.
Okay, all right, thank you. I appreciate that. So, Mr. Whitehead, I'm gonna have Mr. McLean contact you. I know you have some questions, okay? So he'll contact you and answer any questions that you have. I'm gonna instruct him to go ahead, and it's my understanding that you have a hold, or that you have a no bond situation, but we'll see what we can do with this one. And you have a right to remain silent, and anything you say can be used against you. I don't want you to get yourself into any more trouble than what you're already in. So courtroom 2, go ahead and unmute him there. I've let him know, but he's anxious to speak.
Yes, a couple of charges that she said I don't know nothing about. I just got off the phone with Free at last. They confirmed that no one has called them yet. They supposed to call them since Saturday, since I came to court. No one has called the bond company to confirm this. In my FTA, I have a motion to dismiss because they didn't send me the letter. I got it already that it got returned to sender. I'm just waiting on the judge to sign it.
Okay, so we're gonna see if we can resolve. We're gonna see if we can resolve the matter that's
I've been
before
in
me today.
church. I have a job and I can't get out. I'm finna lose my job. I thought I was going today. I'm a licensed dealer and I work at the Walmart warehouse in Union City. I've been trying to get confirmation since Saturday. And then just
Okay, so we're gonna see what we can do, and if something comes through, Mr. McLean, you just send it on over to Ms. Bridgewater and she'll get it to me, and I'll get it signed so that at least this matter will be behind us. If there's something that you can't do, let's put it back on for tomorrow if I don't hear back, so that we can address it at that point in time. But if you do find out something here in the next hour or so, go ahead and let me know, okay?
I
All
think
right.
that's in the next hour, probably half hour to an hour.
All right, very good. Good luck to you, Mr. Whitehead. Thank you. Who do we have next? Do we have some announcements, courtroom 2?
Yes, lead one, he took the other paperwork, but Bivens, I know he's on add-on 1 calendar. I believe he's on, I forgot the numbers for the
He's
calendar.
2 on the regular calendar.
Okay, 2 and 3, I believe. But he's gave a reset. He didn't want to come. Officers went to go get him. He was supposed to go to felony court as well, but he refused.
Okay, so we'll reset Mr. Bivens till tomorrow, 6:10 on positions 2, 3, and add-on 1.
Yes.
Okay.
The same announcement for add-on 2, Mr. Robert Brown. I would say that will be a medical reset in behavior.
Okay, so Mr. Brown, add-on 2 will be medically reset until tomorrow. Okay. What about position 7, Jason Cox?
Yeah, 7 and 13 were waivers.
Okay.
So position 24, Mr. Walker. I talked to his mother. He's going to be reset for attorney. He had a felony court on Saturday, and also misdemeanor, but it was reset because his attorney wasn't available, and he was supposed to come today, but he didn't come today. So she said she's going to talk to him so he can come tomorrow.
Do we know who the attorney is?
It's Everett Walker, Your Honor, according to SCA on Saturday.
So he was on the Saturday calendar and the attorney did not show up?
Correct. And that's why the state has some concerns about this one, because we were told on Saturday that he appeared at the felony first appearance calendar. He got no bond on his felony case. And then Mr. Walker asked it to be reset to today. And now we're being told that apparently Mr. Walker asked it be reset again, that at some point we need to address this defendant's first appearance.
No, I agree with you, Ms. Falk. That's unacceptable that he's not here on 2 separate dates. I can't move on without his attorney, so I'll reset it one more time until tomorrow, 6:10. Let's see.
And can the clerk, I don't know, not to ask them to do this, but is it possible the clerk's office or someone else can get in touch with Mr. Walker? I can also reach out if your honor wishes me to and tell him he needs to be in court tomorrow, but I think it would have
Yes.
better results coming from the clerk's office.
I agree. Ms. Strong, are you with me?
Yes, sir.
Yes, would you reach out to Attorney Walker and just let him know that the court's not happy with him not being here today, especially since he wasn't here on Saturday, and that he must be here tomorrow for this calendar and his client.
And this is for position number
24.
Okay.
Yes. Thank you, Ms. Strong. I appreciate it. Okay, let's address first position number 7, the waiver, Jason Cox, charged in case 25 CR 003245H with theft by shoplifting. Is there a history?
No, Your Honor, no history to report.
Okay, Mr. Sirocco?
Thank you, Judge. And I do have a history. I'm not sure if it was a difference in the names run here or how they were run, but I do see a pretty significant history, at least as far as our charges here concerned. 4 prior convictions from 2023 for theft by shoplifting, and just as well, theft of property and services conviction from 2022 out of Kansas, and a few arrests for one petite larceny 2022 that was sent to the DAs in Oklahoma, and a theft Class C 2022 arrest in Texas. He has opened, from what I can tell, theft by shoplifting cases out of Jackson and Clayton, 2 in Clayton. And it appears that he is wanted, at least as far as us running his GCIC today, out of New Mexico for failure to appear from all the way from 2022, August 10th, 2022. So this incident took place June 2nd at 737 Ponce de Leon Avenue. It's in Atlanta. It's the Green's Liquor Store. Security officer, while entering the building to start his shift, noticed the defendant exiting with alcohol tucked into his pants. The security officer detained the defendant, confiscated the alcohol before officers arrived. And that bottle was a $50 bottle of cognac. And the officers observed video footage of the incident, which showed him stealing the cognac, concealing it, and advised him that he was not permitted to return to the location. He was arrested on scene. Given the previous convictions for theft by shoplifting and other theft offenses, including the open cases that I'm seeing here, the state's recommendation, given the risk of reoffense here, is and I should mention as well, there's a 2025 FTA, 2023 FTA, and 2021 contempt of court I saw. It's out of state. The state's recommendation, given the risk of reoffense and failing to appear, is $1,000 surety, anti-theft course, stay away from Green's Liquor Store at 737 Ponce, and no drugs, weapons, or alcohol while out on bond.
Thank you. Mr. McLean?
Your Honor, Mr. Cox was relatively speaking non-communicative. He did agree to do a waiver of presence, and we need a social worker visit for him. He has no address, and we don't have any resources yet. We need to. So I think we'll come up on the SAP, and at the day, we would ask the court appropriate bond.
Okay, Mr. McLean, if he needs an MHET, would you go ahead and get that order to me as soon as possible so we can get him? I'll have a social worker visit him, but if you assess that he needs that, let's get that process started, okay?
We have communication problem mainly by volume of his voice. He's able to communicate and speak, but he just won't speak up. It's like a whisper. So we'll see what we can do with him.
Okay, thank you. It'll be $1,000 good bond, social worker visit, stay away from that Green's liquor store, and no drugs, alcohol, weapons while out on bond. Let's see, Ms. Strong, can we go off the YouTube video? There's been a request for that for the next case.
Sure.
Thank you.
And did you want me to leave everybody else in the room? Or is that okay?
Oh, just go off the YouTube.
No, I meant for the other people
Oh.
that's in here. Is it okay for them